We head now to our friend Andy McCarthy, who is still in Chicago, I think watching his son play for the University of Chicago baseball team. I understand that we sent him a New York Mets mug. It's good for a Mets fan to get something, since most of the time all they get is losses from my Atlanta Braves. Right off the top, shots at Andy.
Clay bringing the heat, right away.
Andy, by the way, who do you like in the Super Bowl? We probably won't talk to you before then. Do you have a strong lean one way or the other, 49ers or Chiefs?
Yeah, I think the Chiefs I just think Mahomes is, to get into that sort of Montana Brady category, he's got to go on the road, win those playoff games, and get a championship, and then I think he's in that conversation. So I think that's what's happening.
I'm on the other side, by the way, the 49ers. But there we go. We got an easy battle going on there. All right, let's dive into what we got today. D.C. Court of Appeals, I think you would probably say not a surprising ruling that they're not buying Donald Trump's presidential immunity argument. He now faces, the Trump does, and his legal team, the question, does he appeal en banc to the entirety of the D.C. Court of Appeals, knowing that the D.C. Court of Appeals is not going to accept his argument, and then would appeal to the Supreme Court? Or do you think he skips the en banc appeal and goes straight to the Supreme Court? How would you assess where we are right now as it pertains to this Jan 6 case based on the ruling that came down this morning?
Clay, I think equally important with the 57-page opinion, which, as you suggest, is a pretty thorough rejection of the merits of his immunity claim. But probably equally important with it is this one-page, really essentially one-paragraph order that the court issued in conjunction with the opinion. And it's very interesting. What it does is it says to Trump, you have until Monday to file an appeal to the Supreme Court, in which case we'll continue to hold the case in abeyance until the Supreme Court acts on it. But if you instead decide to take your 30 days that the rules of appellate procedure give you to appeal to the full court en banc, and only then, what would happen there is it would get instantly denied, and then he would try to appeal to the Supreme Court. What the court basically says, if you could try to go the rehearing en banc route first, that is not going to stop proceedings in the district court anymore. So you either appeal to the Supreme Court Monday, or this case is going back to Judge Chutkan so she can start having hearings and do the jury questionnaire and all the stuff she has to do to get ready for trial. So
have you ever seen that before?
Nope, I've never seen. Well, is there anything about this where you couldn't put that question to me? There's nothing about this.
But the reason I'm saying I've never seen a court say, if you appeal to us, then we will allow the lower court proceedings to start, basically telling Trump, you're not going to be able to use any more time here. You better go straight to the Supreme Court. If you were advising, I've never seen something like this. So, and to your point, none of us have ever seen anything like this. What would you tell Trump and his team if they came to you in the wake of this appeal? And we all understand that Trump's goal is to avoid this case going to trial, ideally until after the election's already happened, but in a minimum as long as possible. What advice would you give him based on this ruling?
I tell him we have to appeal to the Supreme Court on Monday, because I think the other thing, Clay, that there's another moving part here that we have to consider, which is actually superseded the immunity in importance. And that is that the Supreme Court has already said they're going to hear the obstruction case in connection with some of the January 6th defendants. And even though Trump is not a defendant in that action, he's not a party to that, it's immensely important, because the two main charges against Trump in the election interference are the obstruction charges. So I think as a practical matter, because the Supreme Court's not going to decide the obstruction case until the end of June, Judge Chutkan can't start a trial until sometime after that. I would say, probably late July at the earliest, because she's got to wait for what the court's going to say on obstruction. So if I'm Trump's lawyers, I think I would say to him, look, we've gotten as much out of this immunity thing that, on substance, was meritless, but was valuable to get getting the case put on ice in the district court and achieving some delay. But at this point, his eggs are in the obstruction basket. It's no longer an immunity thing.
Andy, what is from the perspective of Jack Smith, the anti-Trump Democrats, given what we've seen so far, what are they hoping this is going to play out as, right? Like what is their best case scenario as you see it from here on out in terms of obviously a guilty verdict, but in terms of the timing and how it comes down?
I think she's determined to go to trial. They go to trial in late July. I've been saying July 15th, but it was pointed out to me not long ago that July 15th is apparently the start of the Republican convention. I think that would be a little much to start the trial on that day. But I imagine, after that, the hope for them would be the Supreme Court doesn't do much with the obstruction case that would disturb Smith's indictment. And then with little or no tweaking, he can just go to trial a few weeks later. And in the meantime, Chutkan can use this time that she now has, or probably will have, to do all the pretrial stuff that you need to get ready so that they can hit the ground running and go to trial in July. And then they hope, Buck, to, in a federal criminal trial, the defendant has to be there every day. And this is estimated to be a 2 to 3 month trial. So I think they would hope to have Trump sort of not only chained to a courtroom from late July into October, but also day after day after day, the evidence in the case is going to be coming out and being in the public domain and reminding the public of everything they disliked about
Andy,
the Capitol
so
riot.
yeah, I wanted to take it from that perspective so we can kind of know worst case. Now, from the Trump perspective, obviously heavily involving the Supreme Court's actions here, what's best case from here on out?
That the Supreme Court issues an opinion in the obstruction case that not only dismantles the imaginative uses that prosecutors have made of the obstruction statute, but also says, look, just like we said last term in the case involving the two Cuomo cronies whose convictions they threw out, we're telling prosecutors not to creatively use these statutes and stretch them in a way that they were never intended to be used in order to fight political corruption. If Congress wants to write political corruption statutes, they can do that, but it's not up to prosecutors to use the law this way. And if they wrote an opinion like that, and I don't think that's out of the realm of possibility, I wouldn't bet my life on it, that would be a problem for Smith, not only in connection with the obstruction, but also with the civil rights charge and the fraud charge. So I think that's Trump's biggest hope, that the Supreme Court blows it out of the water for him on the obstruction case.
Okay, traditionally, and again, we're talking to Andy McCarthy. Everything we're talking about is unprecedented,
non-traditional.
Yes, in the legitimate use of the word. As a general rule, the Department of Justice has a policy that they do not do political trials in the middle of elections. This has been the standard rule for a long time, even with the idea being that, was it 2022 when they raided Mar-a-Lago? I think they tried to do it in August instead of doing it in October. What we're talking about now, and I agree with you on timing, is the possibility that this case would go to trial right in the middle of the election, right? To your point, Trump could leave the Republican convention and go straight to a courtroom in D.C. and be there for the rest of July, August, September, on potentially into October. This is really crazy. What do you think Merrick Garland would say about that timing and how that would play from a Department of Justice perspective?
I think Garland will say, gee whiz, I appointed a special counsel here, and President Biden and I don't have anything to do with the cases against President Trump, which was the reason, there shouldn't be a special counsel in this case. The reason he appointed, there's no conflict of interest between the Biden Justice Department and Trump, right? There's a conflict of interest between the Biden Justice Department and Biden and Hunter, but not with Trump. But the only reason he appointed a special counsel was so that we could indulge this, that he doesn't have anything to do with it. The Biden Justice Department doesn't have anything to do with it. President Biden doesn't, even though Jack Smith is executing President Biden's power under the auspices of the Justice Department. They're pretending they have nothing to do with it. And then they'll just say Smith's going to do whatever he's going to do, and it looks like he's hell-bent on going to trial whenever he can go. That's clear. They've made up this fantasy new right that the public has an interest in a speedy trial when the Constitution says it's the defendant who has an interest in speedy trial. Public has an interest in a just trial. Trump doesn't want a speedy trial. He wants more time. So I think Smith is absolutely going for it whenever he can start the trial. And it's really going to be up to Judge Chutkan to decide how does she want to be perceived and remembered. Does she think it's unseemly for the judiciary to participate in what would be, to my mind, the Biden Justice Department's obviously politicized desire to get this case to trial at a time that's propitious for them under the election calendar?
Is there any? So, Andy, it sounds like either the Supreme Court steps in here or this thing is going to trial, right? Is that, I mean, meaning either the Supreme Court shoots it down in a way where they can't get the outcome they want, or else you think they will be able to get it through on the schedule where it would happen before the election? Is that the right read?
Yeah, I think it would be terrible to do it that way, but I think that Smith is determined to go to trial, and I don't see, from everything I've seen from Judge Chutkan. Now, look, Chutkan has frozen the case, and Smith did go to her and say, well, even though the case is on appeal, there's other things we could be doing. We could be dealing with motions. We could be dealing with the jury question. And she said, no, it's shut down. So she hasn't been a complete rubber stamp for him. And I don't think she's going to like the perception that, like, if they start this trial in August and you're running right into Election Day, if I'm a judge, I don't want to be, the judiciary is supposed to be there as the protection to the defendant from abusive actions by the executive branch, the prosecution in this instance. And I think it would be abusive under circumstances where the public has an interest in deciding the election itself rather than having the court system decide it. To me, there's no public interest in having this case before Election Day. Smith says, well, the public has a right to. The public knows plenty. The public has the indictment. The public had the January 6th committee hearing. There's nothing about January. We watched January 6th on television. There's nothing about this that the public is going to find out at the trial that is not something we don't already know. What the Democrats are hoping for is it's one big election ad in the run-up to the election to remind the public when they're thinking about a million other things how much they hated the Capitol riot.
Last question for you, Andy. There's another complexity here. Clearly, based on the schedule being changed, and I agree with you, I think late July, probably the earliest at best that they could take this to trial in D.C., the Jack Smith case. What do you think Democrats are telling Alvin Bragg now? Because he would theoretically be first up on the docket. Do they push this one back and wait and put all their eggs in the Jack Smith basket? What if that case gets dragged on and ends up pushing? Because that could happen, right? Like somehow things get bogged down there and they can't start the Jack Smith case, right? Like, or we still have South Florida. What do you think they're telling Alvin Bragg right now? Do you think that case goes to trial first, or do you think they tell him to put that on hiatus?
Well, there's two things with that, Clay. One is that, Alvin Bragg and the Democrats have, the national Democrats, they have kind of the same agenda. They want to see Trump defeated. But Bragg also has his own constituency in New York, right, which is why he indicted this cockamamie case in the first place. So if I'm the Democrats, I don't want the Alvin Bragg case to go to trial because, to me, that's a no-lose proposition for Trump. If he beats the case, it's like a bonanza for him because he's got a powerful argument that this whole lawfare thing was just a bunch of made up nonsense, and it'll be a powerful argument for him. On the other hand, if he gets convicted, it's a really bad case, and I think people are just going to say, "Look, that's New York; they have it in for Trump," and they're not going to care that much about it. So, if I'm the Democrats, there's nothing good that comes out of Alvin Bragg going first. But if Bragg wants to go first, and he's got a trial date that the judge gave him of March 25th, and there's no federal trial, he said he would back off for a federal trial. If there's no federal trial going in March, it'll be up to him whether he wants to push it forward or not.
Just the future of the Republic at stake, everybody. No big deal. Andy McCarthy, everybody of National Review. Andy, thanks for being with us.
Thanks, guys.